Hey everybody, welcome to another episode of Foreclosure Help 777, where we talk about everything foreclosure related. Guys, this is my private Facebook group, and if you're in foreclosure and you need some help, you can join my group, or you can send me an email to foreclosurehelp777@gmail.com, and I'll try to help you with your question. Today we're going to talk about something pretty important regarding a lot of people that come to me with information about securitization audits, and that's what we're going to talk about. But before we go to that, we're going to give an update on Christian Kirsch's case. As you know, Christian is in Pennsylvania, and he had his oral argument last week or so, and this is the judge's order, which is ordered on October 6th. Says, and now the 6th day of October 2025, upon consideration of plaintiff's preliminary objections to defendant's amended counterclaims, responses thereto, a review of the record and oral arguments, it is hereby ordered and decreed and that preliminary objections are overruled. The plaintiff shall file an answer to the amended counterclaims within the time prescribed by Pennsylvania Rule of Civil Procedure, which is 20 days. This order does not constitute a determination on the merits of the claims or defenses raised. All factual allegations in the amended counterclaims are accepted as true for the purpose of preliminary objections only. Okay, so what this means is that his counterclaims survived the dismissal and he can move forward with discovery. And so that's real good news for Christian, guys. Okay, so today's presentation is about securitization audits and Prima Facie evidence requirement in quiet title actions. And Prima Facie is also pronounced Prima Facie. Prima Facie. Okay, just so we know how to pronounce that word. So let's talk about what a securitization audit looks like and why they fail so much, and you shouldn't really argue the information that are in them. This diagram came from the Office of the Comptroller of the Currency in a publication called Asset Securitization. And you can see here parties involved in structured asset-backed securities. At the top of the food chain is, guess who? The borrower. And then it goes to the originator or servicer, which then becomes a special purpose entity and held into a trust. And you can see that the rating agencies and credit enhancers come to play with that. Then you have an underwriter, and then finally investors that purchase the actual securities. And then on that page in the booklet it says borrower. The borrower is responsible for payment on the underlying loans and therefore the ultimate performance of the asset-backed security. Because borrowers often do not realize that their loans have been sold, the originating bank is often able to maintain the customer relationship. Well, guys, that to me sounds pretty tricky for the banks to be doing. You know, it sounds like it's deceitful. What if we did realize that our loans have been sold? Then what? So this publication, I'll show you where it came from. If you go and type in Google Asset Securitization OCC, you'll see the Comptroller's Handbook comes up right here. And it's a PDF file. So if you click on it, you can also download it in PDF right here, see? And then we can open it, and here it is. Look at the year, guys. 1997 they knew about all this scam stuff here. And so it's interesting. If you want to know about securitization and how it all works, this is probably your best book to read about it. So that's that. Now let's get back to the presentation. Okay. Let's talk about the legal foundation prima facie evidence in a quiet title. A plaintiff homeowner suing for quiet title must show superior title than anyone else. The burden of proof is always on the plaintiff. The complaint itself must be properly formatted. You must use short, plain sentences, everything numbered sequentially, parties, jurisdiction and venue, factual background, causes of action, and prayer for relief. Exhibits attached to the complaint must be considered prima facie evidence. Examples of prima facie evidence is the mortgage note and any allonges, any assignments of mortgage or deed of trust, actual affidavits from someone with personal knowledge, bank statements or payment history from the servicer, depositions, and other court documents and rulings. Using securitization audits as evidence. Many homeowners are introduced to so-called forensic securitization audits that claim to prove that the mortgage was not validly transferred. These reports are often used to argue lack of standing, fraudulent assignment, or void trust transfers. Courts across the country consistently reject them as inadmissible hearsay and irrelevant to the borrower's obligations. Understanding why these fail and what prima facie evidence actually means is crucial for effective quiet title and foreclosure defense. Judicial treatment of securitization audits. Homeowners often receive forensic or securitization audit reports claiming their mortgage was not properly transferred into a trust. These reports are typically used to argue that the lender lacks standing or that assignments are void. However, most courts reject these as inadmissible hearsay. Okay, so let's talk about the case study. Freedom Mortgage versus Rayfield. The defendant relied on Joseph R. Esquivel Jr., a private investigator who issued a chain of title and mortgage fraud investigation. Esquivel claimed that the note and mortgage were never properly transferred and were owned by a Ginnie Mae trust. Of course, all this is abusatory nonsense, consistent with Rayfield's history of attempting to litigate by legerdemain. Since Freedom holds both the mortgage and the note, Esquivel's affidavit fails to raise a genuine fact or a genuine issue of material fact. The audit was deemed hearsay because it relied on public documents and data the author didn't generate. It contained legal conclusions, not facts based on personal knowledge. It was irrelevant to the borrower's payment and default obligations. Assignment was executed afterwards is facially invalid. Unendorsed or blank notes produced without authentication. A blank note that is neither properly endorsed nor supported by affidavit of possession does not prove standing. Courts have repeatedly ruled that mere possession of a photocopy or unverified note is insufficient. Fabricated or inconsistent assignments. Okay, so if the assignment bears signature of known robo-signers, notaries who weren't commissioned at that date, or entities that do not exist, the document is facially unreliable. Once fabrication can be demonstrated through public records, signature, or date mismatches, the assignment loses prima facie status entirely. No assignment at all. When no assignment exists and the foreclosing party relies only on a servicing relationship or corporate authority, that is not prima facie proof of ownership, it's hearsay. Okay, so the legal consequence. When a plaintiff's own filings show a defunct assigner, a fabricated document, or an unendorsed note, the court documents and the complaint is properly formatted, often the case will more than likely survive a motion to dismiss, and then a plaintiff homeowner can move forward to discovery and trial, as in the case with Christian Kirsch. As one court put it, where the assignment itself is void, the foreclosing party never acquired any interest in the mortgage and the borrower may challenge it. And that's with Scarretta versus U.S. Bank National Association, California appellate ruling. Courts distinguish between facts, like missing assignment, defunct trust, lack of endorsement, and opinions, which is like the note wasn't properly securitized. The strongest foreclosure defenses come from authenticated evidence, recorded documents, and judicial admissions, not forensic audits. Knowing the evidentiary standard transforms your argument from conspiracy theory to credible litigation. And the key takeaway here, guys, is prima facie evidence must be admissible, authenticated, and based on personal knowledge. Securitization audits fail that test. Why so many people get duped into securitization audits. Desperation and fear. Homeowners facing foreclosure are vulnerable and looking for any hope to save their home. Promises of proving fraud or stopping foreclosure sound persuasive when people feel cornered. Complex legal jargon. Auditors use impressive but misleading terms like remit, compliance, trust closing date violations, and UCC Article 3 defects to sound credible. Most homeowners don't know that these terms have no bearing on whether a lender can foreclose. Online misinformation and YouTube experts. Many foreclosure defense gurus and YouTube videos push cookie-cutter templates, claim securitization voids debt. None of these theories have survived judicial scrutiny, and some have led to sanctions or case dismissals. Lack of access to real legal help. Pro se homeowners often can't afford attorneys and instead turn to self-styled forensic investigators. These reports cost hundreds of thousands of dollars but carry zero evidentiary value in court. False sense of evidence. A professionally formatted audit gives the illusion of proof. Charts, trust numbers, and expert signatures, but without authentication, personal knowledge, or admissibility, they're no more persuasive than opinion blogs. And there's FTC warnings. The Federal Trade Commission issued a 2010 consumer alert titled Forensic Loan Audits, Not What They Claim to Be, warning that these services do not stop foreclosure and often violate federal law. And lastly, if you want to read that case where the forensic loan audit was deemed as hearsay, it is Freedom Mortgage Corporation versus Rayfield. It is out there, and you can click on the PDF. Let's see here. This is the PDF file, so you can actually look this up. It's a Delaware case, and it was decided August 25th, 2025, so it's kind of recent. And here's the case number. As you can see that the defendant, Verlin Rayfield, was denied summary judgment, and the bank won this one. Because they relied on a securitization audit, which is deemed as hearsay. Okay guys, I hope this was informational to a lot of y'all. And if you do have any questions, you can always send me a text message and I will try to answer your questions. And I hope everyone has a blessed day.